Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Good morning, gentlemen.
Good morning, Your Honor.
This is 22-191-505 Debt Holdings LLC versus Kelsey Balling. We were last together on this file on December 15th, and at that time, the court was advised that a motion for summary disposition was forthcoming from the plaintiff. Calendar that motion for today. Appearances.
Hamza Sob on behalf of plaintiff, PA 2080.
Nick Balberman on behalf of defendant P35262.
Counsel, I take it you didn't file your motion for summary disposition.
Your Honor, it was filed and we sent it.
Mr. Balderman, do you have it?
No.
Here, let me, sorry. Hi, Grant Munson, P71994. I'm co-counsel on this case. Your Honor, no, we didn't receive the motion. And when we got the notice, I contacted plaintiff's counsel last week and said, you know, we didn't get it. Can I just get an emailed copy and we'll file a response? I guess the attorney that was handling the case was not there and they were unable to get a copy of the motion, so they couldn't send us a copy. And I think the plan was today that they were going to adjourn the motion so that we could get a copy and hopefully file a response and get you an answer.
Your Honor, we never did receive anything. I know the court set a deadline.
I did not receive it. I'm looking at my register of action. The last action that was in this court on this file was the December 15th date. There's no indication of a motion fee being filed, no indication of a motion being a fee being paid, no indication of a motion being filed. What's going on, counsel?
Your Honor, I was on the matter. I did draft the motion and unfortunately the day I drafted it on December 15th, I indicated to the staff to mail it out and to file it online with the motion fee paid. That unfortunately, Your Honor, my father passed away the past 2 weeks. This is why I haven't been present in the office. I think that's what they're referring to, the miscommunication. So I haven't been to the office or on the file for the past 2 weeks because I was out of the country burying my father. So I'd be more than happy to refile the motion and to send brother counsel a copy of the motion.
Your Honor,
as well.
Your Honor,
Mr. Balderman.
Your Honor, when we were here, when we were in court in December, the court asked counsel, are you filing a motion for summary disposition? He was a little wishy-washy about it, but then he said yes. And you were very specific in your order and said that you gave a hearing date for it. I haven't received anything. You haven't received anything. A fee hasn't been paid. We've called their office multiple times to find out whether it's filed or not filed because they said they were gonna and you set the date. I think that, and I'm all in favor of giving other attorneys reasonable discretion and latitude for things, but here we are a month later and nobody has anything, no motion fee was paid that I know of. And I think this case should be dismissed with prejudice.
Okay, here's what's going to happen. First of all, Mr. Stoll, I'm sorry for your loss.
Thank you, Your Honor.
That was certainly not contemplated by the court or anyone else when we were together on December 15th. There is no basis for dismissal with prejudice here, Mr. Balderman. There's no basis for dismissal at all. Your motion to dismiss the matter is denied. This is what we're going to do. I'm going to adjourn this matter to February 16th at 10 o'clock. What's going to happen on that date, I will set, if I have received it, a motion hearing date on a motion for summary disposition. If not, we'll proceed in another direction. I'll send your file over to mediation.
Thank you, Your Honor.
Thank you, Your Honor.
Again, I'm sorry for your loss. And
Thank you, Your Honor.
not in my court, Mr. Balder, not in my court, not ever. February 16th, 10 o'clock, gentlemen.
Thank you, Your Honor.
Thank you, Your Honor.
We do not take disadvantage of people. You know your fucking mind. February 16th. All right. What's next? Hello?
Good morning, Your Honor.
Morning. What brings you here today, counsel?
We are here for a settlement conference for OrthoCore Tyrone Williams. If you need the case number, I can also provide that for you as well.
I do need your case number because I don't see a Tyrone Williams on my file here.
Sure, it is 22-189534 GC.
189534.
189534, yes, correct.
You're in the wrong room, counsel. You're not on my docket today.
Oh,
Give me your case number one more time, please.
sure. It is 22-189534. We had agreed to settle, we agreed with the facilitation recommendation, but we haven't received confirmation with opposing counsel whether or not we were settled. So maybe it was settled and it was removed from the docket, but we never received confirmation.
I think you're in the wrong place. Let me check with my court clerk, please.
Okay.
Mr. Ashton, I believe, is here in your case, counsel. There he is here. There we go.
Mr.
Ashton. And the
Judge.
name of your case is not Williams. Your client is CR539 Corporation. Gave me-
Yes, orthophore, yeah, with the underlying patient as Tyrone Williams, yes.
Yeah, but you gave me Williams.
I apologize.
I'm looking for the wrong place.
Okay, so you said Judge Ashton is the
No, Joel Ashton is here.
Joel Ashton.
Get him in and let's find out what's going on.
I'm here.
This is
Oh, with
file
that.
number 22-189-534. CR539 Corporation versus City of Detroit. Could I have your appearances?
Yes, this is Zainab Baji, P number 86182 on behalf of orthophore, the plaintiff.
Counsel?
Joel Ashton, P number 47039, appearing for defendant, City of Detroit.
Okay, where are we on this file?
Your Honor, we have facilitated the case. We have a
Mhm.
tentative settlement, and on December 8th, I submitted the required paperwork for review by City Council, and we are anxiously awaiting their review of same.
No answer, but from City Council, in other words.
Correct. And I know they were off for part of that time period. I believe they're back in session now. So it should be in their to-do pile.
Yeah, I'm sure, along with other things. All right, I'll have you guys back February 16th at 10 o'clock. Hopefully by that time, they'll have made some kind of decision. Thank
Do
you
what we can.
for coming in.
Thank you.
Thank you, Your Honor.
Let's be safe out there.
Thank you. You too.
Bye-bye. Mr. Boyke,
Good morning, Your Honor.
you're representing Progressive Michigan?
Correct, Your Honor.
Okay, let's see who this is. I think it's Herschel.
It might be Rachel Schwartz, Your Honor. I don't think Connor.
You think it's Rachel? All right, let's try that.
Morning, Your Honor.
Good morning, counsel. What file do you have?
We are here on Richard Oswald versus Progressive.
Okay, this is Richard Oswald versus Progressive Michigan Insurance. This is 22-187-674. Could I have your appearances?
Rachel Schwartz on behalf of the plaintiff P54947.
Charles Boyke on behalf of the defendant, P77261.
All right. Did we get the deposition of the plaintiff accomplished?
Yes,
We did, Your Honor.
Okay. So then why aren't we settled?
We got it accomplished last Thursday or Friday, Your Honor. And so plaintiff's counsel and I were beginning our settlement discussions. She was going to call and confirm the medical outstanding debts. So we were at it actively, and hopefully we'll get it resolved here in the next week or so.
All right, let's give you a return date and get you on your way. February 16th, work for both of you at 10 o'clock?
Just,
Um, no, I have 3 settlement conferences that morning.
All right, then how about February 13th, that Monday?
That's pretty bad too. Can you do the 14th?
Does the 14th work for you, Mr. Boykin?
I have an in-person settlement conference at 10 a.m. so I
It's
could,
not going to work.
What time on Monday, the 13th, did you say? 10?
10 o'clock? Like,
I have to be in front of Judge Coleman in your court at 9:45,
oh,
so,
that'd be fine. Does the
okay.
13th work for you, Mr. Boykin, at 10 o'clock?
I can make that work, Your Honor.
All right, February 13th at 10 o'clock. We'll talk to people again. We'll see where we are.
Okay, thank you.
And
Thank
I'll
you.
go today. Thank you. Let's be safe.
Good morning, Your Honor.
Good morning. This is file number 22-187988. Ledvivia Hereford versus the Liberty Surplus Insurance Company. Could I have your appearances?
Good morning, Your Honor. Doug Harriskevich, P81458, on behalf of the plaintiff.
Good morning, Your Honor. Shanavia Smith, P84090, on behalf of Defendant Liberty Surplus.
All right. Last time we were together in December, we were getting a psychiatric IME on the plaintiff. Has that been done?
Your Honor, it has been
Your Honor.
scheduled for February 6, 2023.
It's scheduled for again?
Yes,
February what?
February 6
Okay.
of
So let's
2023.
see, guys, February 14th at 10 o'clock.
Okay, thank you, Your
I
Honor.
don't expect you'll have the report by then, but I expect we'll be confirming that the IME has been done and we can get this file moving one way or the other.
Understood, Your Honor. Thank you very much.
Thank you so much, Your Honor.
Let's be safe out here.
You as
You
well.
as well.
February 16, February 16 at 10 o'clock. We'll see you then.
Okay, perfect.
Thanks
Thank
for
you.
coming in. Just be safe.
Thank you, you too.
We're off the record.
Good morning, Judge.
Good morning.
Good morning, Your Honor.
Okay, this is file number 22-183670, Midland Credit Management versus Delia Soto. Could I have your appearances, please?
Andrew Perry, P69402 on behalf of plaintiff.
Brandon Jansen, P78132 on behalf of the defendant.
All right, last time we were here, counsel, you didn't appear. What's going on here?
Judge, I had a COVID at the last time. I let my secretary know to let the courts know. Apparently that did not happen. So that's what happened at our last hearing.
All right. Where are we on this file?
So I was able to reach out to Pure Debt Solutions. They are still negotiating this debt, and they essentially told me to stop everything or they're going to take the debt off her file. So they want me to let this motion for summary go to a default essentially, and then they're going to work out the settlement on the back end. I didn't quite understand why. They said they spoke to you guys in June. And that's essentially the direction I got from this Pure Debt Solutions, that if I went forward with this case, they were going to cancel it out of her debt collection agreement that she had previously made with them. But they said they're still on it and negotiating. And that's all the information that her agent would give me directly.
All right, well, they're not going to control my docket here. That's foolishness.
No, I understand that. They're saying let a judgment be entered and they'll settle it from there.
All right, are you then willing to stipulate to the entry of the order for the motion for summary disposition?
I am, Judge.
All right, Mr. Perry?
I have no objection.
Well, I guess not, since it's your motion. What you're going to do then, Mr. Perry, given counsel stipulation, is you are going to submit a stipulated order granting your motion for summary disposition along with your proposed judgment.
All right. So, Mr. Jansen, I'll send you the proposed stip to review and sign. And then once you return it back to me, I'll sign and send it to the court for entry.
Yeah, that'd be perfect.
Okay. What I'm going to do, guys, is I'm going to give you a February 16th return date. I don't expect we'll need it. We should be able to finish this before that time.
I agree, Judge.
Do you have my email, or you can look it up? Or
yeah, I'll take your email right now if you don't mind.
No, you won't. I'll put you guys into a chat room and you can do it.
Thank you.
The whole world needs to know his email.
Perfect.
Unless you're famous or something.
No, I'm not.
Okay. Well, why don't we do this in the chat room then? Okay.
All right. Thank you.
When you guys are done, just go ahead on and take off. Look forward to your paperwork, Mr. Perry.
All right. Thanks, Judge.
All right. Let's get you guys to a chat room.
We in it?
Not yet.
There we go.
I'll take a minute.
It'll say joining breakout room.
We'll say join, then you hit it, and then you'll see going. You'll disappear from my screen.
Have a great day, Judge.
Johnson, Mr. Perry will be joining you shortly. You'll hit join, and he's gone. Good morning, Ms. Francis.
Morning, Your Honor.
What is your name, ma'am? In the car, what is your name? We don't seem to be connected. I'm connecting to one other audio. Hello, who was there?
Now I can't do my state job.
Hello,
Hello, can you hear me?
what is your name?
Teresa J. Moss, sir.
I'm sorry.
Teresa J. Moss.
All right. And you're under someone else's name here. I see the problem.
Oh, no,
You're not Almond Markham, are you?
no,
That's
no.
the problem. All right. Now I have someone else.
I can't see.
Just stay there. I have someone else
Okay.
who's trying to connect to audio.
She cool. Come here. Oh. Wait a minute. I'm still on break, so I'm.
All right. What is your name again, ma'am?
Teresa J. Moss.
Okay. I don't know who this other person is.
I see. Who, where?
Do you recognize this person?
No.
Miss Francis? Okay, well, we're gonna move on.
Apologize.
Because I don't understand what's going on here. You don't,
I
well,
don't know.
wait, they're connecting audio. Let's see if they can connect. Otherwise, we're gonna proceed with our motion.
Thank
I don't know who
you.
this person is. That connection is apparently not happening.
Okay.
They're out of the car now. We're gonna move forward.
Thank you.
Put whoever this is in the waiting room. They're not part of my lawsuit in any event. We are on the record calling file number 22-179-699, Modern Financial Services versus Teresa Moss. Date and time for a motion for summary disposition filed on behalf of the plaintiff. Appearances.
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record P72322.
And what is your name, ma'am?
Teresa J. Moss.
Ms. Francis, your motion.
Thank you, Your Honor. We did file our motion under MCR 2.1169 and C10 and I1. Your Honor, defendants answer and even her counter complaints admit that she did enter into the contract agreement with plaintiff on 12/2/2019 to purchase a 2016 Chevrolet Cruze. She then defaulted on her payments, causing plaintiff to have to repossess the vehicle for failure to pay, and then the vehicle was sold, and this is the deficiency balance after all of those funds were applied, Your Honor. So there is no issue of material fact remaining for trial, and defendant has not listed any valid defenses, so we are asking for our motion to be granted.
Your response, ma'am.
I'm not understanding why she's saying there's no defense. I have no defense. I do have a defense, ma'am. I spoke with Modern Finance as much as possible. When they said when they came out, they said no one never talked to me. I talked to them between at least 25 times through this whole process of the car. The car had been in an accident, an automobile accident. I called them that day, or maybe the next day, but I got in touch with them with the blue book to let them know that the car had been in an accident and needed to be repaired. And I was instructed if through State Farm Auto Insurance that the car could be totaled because malfunction could happen once I had the car repaired. So I called the office. They told me that I had the I can't think of the rest of the money for me to pay if the car got totaled out, that I had the insurance for the rest of the car to be covered.
Okay. Anything else you want to tell the court?
Yes. And so it was through the holidays, which everything was closed. I went to have the car looked at like I was told to do per State Farm Insurance. Because again, they had told me that the car would be totaled. So I called Modern Finance. I spoke with Rick and the young lady, and I told them per State Farm, per the people that had looked at the car, the collision shops, that they said the car would be totaled. So then after the holidays, I went back to one of the people because they called and they said that bring the car back in and we're going to look at it again. Every time I spoke with State Farm, who instructed me to make sure that I stay in touch with Modern Finance to let them know exactly what's going on, I did. I called. So when they looked at the car the second time, the same place, they said, oh, we can fix it. I informed Modern Finance that the car was going to be fixed. Through all this process, no one never mentioned anything about if I had the money to get the car fixed, why wasn't I instructed about they're going to repossess my car? They let me get it fixed, told me I could make the payment. I told them when I would have the payment. And I did exactly what I was instructed to do. When they came out to my house, when they repossessed the car, the payment was already taken out and the car was paid for. As far as the total fees for being fixed.
Ms. Francis, let me hear from you.
Your Honor, defendant did make a payment. She did not catch up on all of her arrears. She did default on multiple payments. So just making one payment does not cure the default that she was already in. So she was still in default and plaintiff had the right to repossess the vehicle. We did apply the funds towards her account. And again, this is the balance remaining under the contract.
All right, the court's prepared to rule here. This is a motion under MCR 2.116 C10. The relevant court rule here is MCR 2.116 G4, which provides that when a motion under sub-rule C10 has been filed, the opposing party must, by affidavits or otherwise provided in this rule, set forth specific facts showing there's a genuine issue for trial. No affidavit has been submitted here. The pleading that was submitted on behalf of the defendant basically talks about having a problem because of the COVID. Well, that's certainly something that we all agree happened in the real world, but it's not a defense in the case. Court finds that there is no genuine issue of material fact. The motion for summary disposition is therefore granted. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Ms. Francis, I look forward to your judgment under the 7-day rule. Thank you both for coming. You're off the record.
Sorry, Judge, one more issue. Is the counter complaint still pending as well? We would ask for that to be dismissed if it is.
Well, yeah, there was no response filed in regard to that aspect of the motion. That is granted as well. So that'll have to be part of your order. You're granting a motion for summary disposition, granting the dismissal in regard to the counter complaint, and you're sending a proposed judgment. So your order should do those three things. Thank you, ma'am, for coming in. We are off the record.
Thank you.
Thank you.
Have a good day. Hello? Hello? Hello?
Hello,
What is your name?
Elisa Botchway.
Why are you here, ma'am?
I have court today at 11.
At 11. All right.
Yes,
I'll put you back in the waiting room until then.
okay, thank you.
This is done. All right, let's turn on the music.
by the composer, you have detail who was a composition student on the back. Sebastian Bach, one of his last students. He lived from 1728 to 1788, so his there's a type of this. You'll find three detail. This music here on this is WLCJFM control.
Mr. Kavanaugh.
Good morning, Your Honor. How are you?
Good. How are you?
Good.
I have a couple of matters that I'm going to get to before I call you guys, because obviously you're going to take some time. But I just want to let you know I know you're here, and we'll get to you as soon as I can.
Thank you, sir.
Good morning, Your Honor.
Good morning. We are on the record calling file number 22243350, Elisa Botchway versus Livernois Oral Express. This matter comes to us by way of removal from a matter in the small claims court. Date and time for pretrial, your appearances.
Michael Holmes, Your Honor, on behalf of the defendant.
Bar number.
P46095.
What is your name, ma'am?
Elisa Botchway.
All right, Ms. Botchway, I want to explain something to you that you might not understand, but it's important that you do. You started the matter in small claims division. The matter was removed, as is the right of the defendant, to the general civil docket. The general civil docket is very different than small claims. In small claims, lawyers are not permitted. In small claims, the rules of evidence other than privilege are not followed. In small claims, the judge is not required to follow case of statutory law, but is to do, quote, substantial justice. That is not where we are now. We are now in the general civil docket. In the general civil docket, I am required to follow the Michigan court rules, rules of civil procedure, Michigan case law, and statutes. Their lawyers obviously are permitted. As you can see, Mr. Holmes has appeared on behalf of the defendant. I say that to say that you started a very informal proceeding. This is no longer an informal proceeding. There is one set of rules, and that set of rules will be binding on both you and Mr. Holmes, whether or not you know those rules, whether or not you understand those rules. So the first thing I want you to understand is how different the environment is than small claims. Secondly, let me urge you as strongly as I can to get a lawyer to represent you. You, of course, have an absolute right to represent yourself. What you do not have, however, is the right to your own set of rules, civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that are binding on Mr. Holmes will be equally binding on you. You understand these things?
Yes, sir.
Okay. So Are you intending to continue to represent yourself, or are you going to get a lawyer? Again, that's your decision, ma'am.
Only thing, I don't know, because only thing I'm trying to do is say what happened to my car, and they have my car in their possession. They had it for a long time, so I'm just trying to resolve the matter, sir.
Okay, this is what I'm going to do. I'm going to continue your written discovery. I'm going to give you a return date. Your return date with me will be February 16, February 16 at 11 o'clock. If you decide to get an attorney, ma'am, and again, like I said, you have an absolute constitutional right to represent yourself. If you decide to get an attorney, have the attorney file the appearance. The appearance is a document by which the attorney says he or she will represent you. Anything else we can do today?
I'm all set, Your Honor. I did.
You, ma'am. Anything for you, ma'am?
Is it a way for me to get videos, send him videos, send you videos or something for evidence in my,
well, ma'am,
about
if we get to the point where we have a trial, then your evidence will be submitted as like an ordinary trial. But we're not at this point. At this point, we're at the discovery phase. Discovery is an opportunity for you to learn by written discovery, which is what I'm opening today, things by the claims and defenses of the other people. Those would be things like written questions to be answered under oath. They're called interrogatories. Requests for production of documents or things, and requests for admissions. So again, if you want to represent yourself, you got an absolute constitutional right to do that. Or I would urge you to get counsel, but again, that's going to be your decision. Your written discovery is open. I will see you people again February 16th, February 16th at 11 o'clock. We'll be
Thank
on
you, Your Honor.
like today. Thank you both for coming in. We're off the record.
Thank you, sir.
Morning, counsel.
Good morning, Your Honor.
What is your name, ma'am?
Elvira Davis.
All right, we are on the record. This is file number 22-190-250, Discover Bank versus Elvira Davis, by a notice dated December 14th, 2022. This is the date and time for the motion for summary disposition filed on behalf of the plaintiff in this matter. Ms. Davis, first question is, did you file an answer to this motion?
Yes,
When did you file an answer to the motion, ma'am?
I filed an answer to them. I came in yesterday and filed an answer to the motion.
Yesterday?
Yes,
Did you serve a copy of the answer on the other side?
she provided me a copy.
No, ma'am, I'm asking you whether you served a copy of your answer on the other side. You're the defendant, that's your obligation. That's not the court's obligation.
Right, so, okay, so initially, yes, I filed an answer to the first motion. Then when I came in yesterday, she told me I already filed my answer. And I said, I was stated that I had to file another answer. There was some additional paperwork sent to my home. So I should write out a statement. I put in my statement that I do not agree with the terms that the plaintiff is requesting. And she stamped it and gave it to me, but I initially filed my answer a while back.
You filed an answer to the complaint, ma'am. My question was an answer to the motion for summary disposition.
I filed the answer. I came in yesterday and that's what she gave me.
All right. I'm obviously not positioned to appear this case today since you filed an answer yesterday. Ma'am, the court rules. All right, I'm gonna give you a new date on the motion.
Your Honor, what I would just indicate to the court is we didn't receive a copy of the answer, and defendant should certainly send us a copy of her answer. If her answer is alleging anything other than leaving to proof, which she indicated in her answer to the complaint, then obviously, well, I guess we can address that at the time.
Yeah. All right, what I'm gonna do is I'm gonna adjourn this matter. Ma'am, if you filed an answer, you must serve a copy of that answer on the opposing counsel. Do you understand that? That is your obligation. That is not the court's. Do you understand that?
Yes.
All right, I'm gonna adjourn this matter to February the 16th at 11 o'clock. I'll send you out an order. Thank you for coming in.
Thank you, Your Honor. Have a good day.
Sorry, Your Honor.
Ma'am?
I'm sorry. You said February the 16th?
At 11 o'clock, yes, ma'am.
Okay, may I ask a question?
What is it, ma'am?
In regards to me filing an answer, is there anything that they could send me again that I need to answer to? I don't have anything additional than what I've already received to my home, and nothing stated that I had to file an answer. I understand that you're telling me that I have to file an answer, but I went downtown, I came down there yesterday and I filed an answer, and I guess that's not what I needed or something. I apologize that I'm misunderstanding what I need to do. So I'm asking, can any additional information be sent to my home?
Ma'am, I'm not in a position to give you legal advice.
Okay.
I can't do that. I can't give legal advice to one side or the other. February 16th at 11 o'clock, we'll hear this motion. Thank you for coming in. Make sure you serve a copy of the answer that you filed on counsel for the plaintiff. Thank you both for coming in. We are off the record.
Thank you, Your Honor. Have a good day.
Okay.
It's at 313-576-5111. January 19th, first and the focus. That's a live broadcast too. We're radio. I hope you can listen to us. You're not able to actually see us. Broadcasting the concert tomorrow at 10:40. And down comes down at 10:45 when the concert begins. To be a American conducting the control system of this track, Edgar Moroza, Charles Soloist, it's live on the radio. George Sherman's music next. This is his solo cello piece, The Gardens of Exile. Peter Raybo, hearing this. This station serves the Southeast Michigan local operational area. Includes the EAS system.
We are on the record calling 21-171-918 Washira Oliver versus Stephen Edward Paulson II and a Bearded Builder LLC. Date and time for the motion for summary disposition filed on behalf of both defendants, your respective appearances.
Good morning, Judge Peter Kavanaugh appearing for the defendants, Stephen Edward Paulson II and a Bearded Builder LLC.
Your bar number,
P53537.
counsel.
Good morning, Your Honor. Alex Green IV, PA2657, appearing on behalf of Plano with Shira and Ms. Oliver.
All right, gentlemen, I've had an opportunity to review your pleadings. Thank you both for these submissions. Let's hear from Mr. Kavanaugh, followed by Mr. Green, rebuttal by Mr. Kavanaugh. Gentlemen.
Your Honor, as the court knows, this is a motion for summary disposition brought under MCR 2.116C8 and MCR 2.116C10. Defendant's motion seeks dismissal of all three plaintiff's claims, which consist of a breach of contract, count 1, negligent misrepresentation, count 2, and unjust enrichment, count 3. The plaintiff acknowledges that it has pled multiple claims, but there is only one prayer for relief, Judge, that seeks restitution and equitable relief. The dollar amount claimed is in the nature of restitution. That's the $9,863 figure.
62, I think.
Or 62, I'm sorry. But that is precisely when Mr. Oliver was questioned in deposition, what are your damages? Those were his damages, and he acknowledged that what he was seeking was repayment of monies paid to a bearded builder, LLC, as a deposit, his contention being that work was not done and that there was no accounting for the money. So it's not contract damages in the sense of I paid somebody else to finish the work was defective, I had to pay for repairs. It's in the nature of restitution. The undisputed material facts in this case, Judge, coupled with the plaintiff's failure to plead all of the required elements for a fraud claim, coupled with the fact that Michigan law does not recognize a private cause of action by a homeowner against an unlicensed residential builder, coupled with the fact that Mr. Paulson made no representations whatsoever to Mr. Oliver about his licensure status or the licensure status of a bearded builder. Therefore, there was no misrepresentation, no reliance on the part of Mr. Oliver, coupled with the fact that the contract document and Mr. Oliver's testimony clearly indicate that he knew he was contracting with a bearded builder LLC, not Mr. Paulson individually. In fact, one of the checks that is accompanied the response brief is a cashier's check made out to a bearded builder LLC, not Mr. Paulson. Your Honor, in response to the motion, the plaintiff was to have identified the material facts he claims or contends are in dispute that would warrant denial of this motion. And in fact, that's under MCR 2.116 G4. Plaintiff does not identify the material facts he thinks are in dispute. Moreover, there is no affidavit of Mr. Oliver in support of his response, and we're left with his sworn deposition testimony, which supports summary disposition for the defendants. For these reasons and those set forth in the motion and brief filed by the defendants, Stephen Edward Paulson II and a bearded builder LLC request that the court dismiss plaintiff's claims in their entirety.
Mr. Green.
Yes, Your Honor. First of all, yes, the defendant's counsel is correct. We did plead 3 counts: breach of contract, negligent misrepresentation, as well as unjust enrichment. However, the same case that defendants rely on, Epps v. Four Quarters Restoration LLC 498 Mich 518-2015, states that yes, there is no independent cause of action for the recoupment of monies paid to an unlicensed residential builder. However, the case talks about whether a contract should be void ab initio or voidable. And so it is our contention that either way, our client or Mr. Oliver has sustained contract damages because nothing that he paid for was completed, and he spent an additional $15,000 plus as though he never paid any money to the defendants.
Doesn't the Four Quarters case say that the decision of the court was that the options were a void ab initio contract or a voidable contract? And the court decided that the contract would be voidable, not void ab initio. Isn't that what the court held?
The court held that whichever outcome is most favorable to a particular plaintiff. So it could be void or voidable.
All right, please continue, Mr. Green.
Okay. And I do have Mr. Paulson's sworn testimony that he has no photos of any completed work. He does provide some receipts, but the receipts merely show that some monies were spent to it and paid to buy some material from a distributor or retailer that may or may not have made it to the job site. Many of the items that were on the job site were ruined and were not installed properly. These are not just movable. This is not movable furniture. We're talking about custom cabinets, talking about flooring, plumbing, electrical. And I asked within the deposition to Mr. Paulson to estimate the value of the work that he did based on a letter that Mr. Oliver's then counsel wrote to defendants, Mr. Kavanaugh response letter, which alleged that over $7,000 worth of work had been done. But again, there's nothing except his own assertions that that work was done. And the best evidence that any construction work is done is some photos or, something other than I did it. I also have an affidavit from the completion contractor, Gino Ali Fawaz.
This is a licensed residential builder as well?
He's not like, I do not believe he's licensed.
Indeed, please continue.
However.
I read the stuff, Mr. Green.
Okay, yes, he is not licensed. Okay. However, yes, our claim centers around the fact that the work wasn't done properly. Okay, whether or not Mr. Paulson was licensed is only part of the inquiry, right? I'm going to refer back to the Epps v. Four Quarters restoration case to stand for the proposition that the public policy behind residential builders having to be licensed is to protect unsuspecting homeowners from fly-by-night contractors who attempt to defraud them or take their money or otherwise, a homeowner doesn't know whether to ask those questions often.
But whose job is it to enforce that public policy? Doesn't the case say that it is not a private cause of action, but is indeed to be done by a prosecutor?
That's only for, as it relates to any criminal liability. There's still a breach of contract for work that's not done. I'm not saying that the breach of contracts arises out of his unlicensure, the fact that he's unlicensed. I'm saying that the breach of contract arises out of the fact that the work wasn't done properly. And oh, by the way, he's also unlicensed. So I don't have any, there's that, it's almost as though he doesn't meet the, we argue that he doesn't have the capability. He never showed any photos of any work he's done previously. He did come recommended, but, we're not convinced that he even knew how to do the work. And there's no evidence that he did. Furthermore, when it comes to this idea of a bearded builder versus Steve Edward Paulson II, and whether the contract was with the company by itself or with both, first of all, Mr. Paulson admitted in a deposition that he had a business account allegedly in his own name, but we don't know whether that's true. I asked in request for production of documents to produce some bank statements that would show that, and I received nothing. I don't, it could have been in his bank name, it could have been in a personal name, I have no idea. He did also admit that, he doesn't know when he started the business account for a Bearded Builder LLC. And the contract from December 4th, 2018 says to make checks payable to Steve E. Paulson II. Not
Doesn't that same contract in the upper left-hand corner identify two parties? It identifies a bearded builder LLC, and it also identifies Stephen Edward Paulson II dash owner.
Yes.
Here on the
Yep.
contract?
You're absolutely correct, Your Honor. And he is a sole proprietor, yes, of that. However, there are
So the
factors.
contract itself indicates that a bearded builder is an LLC and that Mr. Paulson's status is owner of that LLC. That where we are?
That is true, Your Honor. However, I would argue, plaintiff's argument is that even if the court finds that, a bearded builder LLC, the contract with a bearded builder LLC, the elements are met here to pierce the corporate veil. Okay. The court looks to in Glenn v. TPI Petroleum, a 2014 Michigan Court of Appeals decision, whether the corporation is undercapitalized, whether separate books are kept, whether there are separate finances for the corporation, whether the corporation is used for fraud or illegality, whether the corporate formalities have been followed, and whether the corporation is a sham. To the extent that Mr. Paulson called himself a builder when he had no residential builder's license, the corporation is used for fraud or illegality and is a sham. The average person would believe that a person who had a builder in a title of his company would actually be a builder. If he had endeavored to do commercial work that doesn't require a builder's license, that's one thing, but this was a residential building project. And it's clear, in fact, the defendants admit that the kind of work, the nature of the work that they were to complete required a residential builder's license. So in this particular case, it appears that a bearded builder LLC is a mere instrumentality of Steve E. Paulson II.
Anything else you want to tell the court?
I'd also like to touch on, again, the standards for summary disposition. Okay, we're talking C8, which is failure to state a claim.
We're really out of the box on C8, given the fact that both of you have submitted matters beyond the pleadings. This is really a C10 motion. And the court is of the understanding that questions of fact ought to be liberally construed in favor of the party opposing the motion. Anything else you want to tell the court?
Other than the fact that we've submitted an affidavit that I think speaks for itself, the fact that we've submitted photographs of unfinished work, and the fact that we allege that most of the items had to be removed from the kitchen and redone, the fact that there were checks totaling over $15,000 to the completion contractor, I think that the plaintiff rests its case.
Mr. Kavanaugh.
I have only one comment, and that is this argument about piercing the corporate veil is brand new. It's not part of any of the pleadings in this case, and I think the court should disregard it. With regard to the rest of the matters, I'm going to rest on my brief. I have nothing further to say.
All right, the court is prepared to rule in this matter, and I want to thank you both for your patience in this matter. I screwed up the last scheduled date because I had not calendared correctly, so the case came up for hearing before I'd had a chance to review the pleadings. I've had that opportunity. The ruling of the court is, let's start with it. First of all, it's significant, and again, I'm treating this as a C10 motion, and I recognize that under C10, there must be a genuine issue of material fact, and the question of whether there is a genuine issue of material fact shall be liberally construed against the moving party, or put another way, in favor of the non-moving party, if the existence of such a fact. The contract here, which is Exhibit C to our complaint, is to repair, remodel the kitchen in a workmanlike manner and in accord with state and local building codes. The contract signed on 12/4/18 has basically two names in it. In the upper left-hand corner, we have identified A Bearded Builder LLC. Below that is Stephen Edward Paulson II. And that those two names are distinguished by the fact that Mr. Paulson is identified in that contract head as owner. Further, the only signature there on the lower right-hand corner is signed by Stephen Edward Paulson over, not a signature by Stephen Edward Paulson, over the signature block for a Bearded Builder LLC. It apparently is uncontroverted that Mr. Paulson and the Bearded Builder did not have license for the work that was being done in this residential area. The statute that provides protection for the public in this matter does not allow a person doing residential or a business doing residential work which is not licensed to recover. However, that is not a private, given under the Edwards case. Number one, this is not that, like Edwards, this is not that case. This is not the case where the unlicensed residential builder is seeking to recover damages or payment. This is a case where the customer is suing the residential builder. Now, in this case, the contract amount for exhibit number C was plaintiff's exhibit C was $15,525. And the claims that are raised by the plaintiff, which are in our complaint, we have completed discovery, discovery has been closed, are for breach of contract, negligent misrepresentation, and unjust enrichment. No mention is made in the complaint of piercing the corporate veil. Mr. Green has identified in his brief a list of factors which are to be used in evaluating whether or not the court should determine to pierce the corporate veil. Listing those factors is not the equivalent of proof that the factors have been established by competent or admissible evidence. Further, the case cited by the defendant in this matter concerning the way the job was terminated, that the job was terminated without previous notice of default. This is a major breach of contract by the customer. That's what the case law is quite clear in that regard. In regard to the claim of $9,862 in damages, statutory interest from the time of the contract, reasonable attorney fees and costs, and a cease and desist order under MCLA 339-601-9, which is requested by the plaintiff. Let's look at them from out of order. First of all, in regard to a claim for a cease and desist order, this court lacks subject matter jurisdiction. The only equitable jurisdiction that the 36th District Court or any district court has is in two contexts. One, in the context of summary landlord proceeding concerning possession of a rented property. And number two is to enforce its orders. The fact that the court has equitable jurisdiction to enforce its orders does not confer subject matter jurisdiction to grant equitable relief, which is what's requested. Likewise, looking at the bounds of the contract, which is appended to the plaintiff's exhibit C, there's no provision in that contract for attorney fees. Attorney fees in Michigan are governed by the American rule, which is that in general, in the absence of specific statutory provision or court rule, such as, for example, case evaluation situation, each side must bear its own attorney fees. The English rule is that the side that prevails has its attorney fees paid by the losing side, but that's not the applicable rule here. The question of statutory interest from the time of the contract, again, that's a matter of law. If the judgment is entered in favor of the defendant, a plaintiff, this interest is statutory. The complaint here does not allege that the work was not done in a workmanlike manner. And again, as I pointed out earlier, it does not allege piercing of the corporate veil, that the corporate veil should be pierced here. There is no general issue of material fact in the court's view that this was a contract between and indeed this was a testimony of your client under oath, he believed he was contracting with the business, not that he was contracting with Mr. Paulson individually. There's no genuine issue of material fact here. We do not have enough to pierce the corporate veil. There is no showing, no fact whatsoever, even construing matters most liberally in favor of the non-moving party, that says that Mr. Paulson contracted individually here. Summary disposition as to Mr. Paulson, the individual, is granted. The court plaintiff lacks standing to enforce the Michigan Occupational Code as a private attorney general. And the Flam versus Shearer case says that plaintiff committed a material breach of contract by failing to make the second $3,000 payment and by having a second contractor remove the defendant's work without prior declaring a default or terminating that contract. Further, Michigan law does not provide a cause of action to recoup monies paid to an unlicensed residential builder if the work required a residential building license and the party doing the work did not have it. That's what Epps tells us here. I'm satisfied that there is no genuine issue of material fact as to the claims of this matter. The motion for summary disposition filed on behalf of both the defendant, Bearded Builder LLC, and on behalf of Stephen Edward Paulson, second is granted in full. The case is dismissed. Mr. Green, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out to both of you gentlemen an order dismissing the matter on summary disposition as to both defendants. Thank you both for coming in, and I appreciate your patience. Let's have a great day.
Thank you, Judge.
Be safe, gentlemen. We are off.
Thank you. Judge, will this be? No.
I'm sorry.
Mr. Green's gone. We can't talk.
No, okay, I'll send out an order.
Thank you.
As I indicated.
Okay, thank you.